Hello, everybody. I'm Ann McKinney of the law firm of McKinney & Tillman, and I'm here to go over with you some things that I think may be on your minds, certainly on our minds, in this very unusual environment. The world, as we know it, has changed virtually overnight. I remember when we started the year of 2020, the president had just signed the Secure Act, which had an enormous impact on how retirement money was going to be distributed when our clients died and passed their retirement funds on to their family members, because the income taxation is now very, very different from the way that it was in all of the years that I can remember prior to 2020. Now, as you can learn in our video on the Secure Act and from our handout in the free resources section of our website, passitonwell.com, the taxation of retirement benefits for beneficiaries like your children, your grandchildren, anyone but a few categories of individuals is very different now. Those retirement funds are going to be required to be distributed to most people after the participant and his or her spouse are both gone, must be distributed over 10 years. Doesn't have to be equally over the 10-year period. You can wait till the very end. You can take it out all at once at any given time. But planning for all of that income tax to be paid by your beneficiaries is a very different challenge now than it was before. So we put together a seminar for our clients. We did a location in Knoxville and a location in Tellico Village. We put our video, pretty long handout on the web at the free resources section, and we're rocking along, and then this virus occurred, the event that really is changing so much of our world. And now that we realize that many of you are confined to the house, you're self-quarantining, isolating, and so on, we want to give you some homework and some information and some tools, some things that you can do while you're sitting there at the house that might help in terms of estate planning. So I want to start with IRAs because we've been talking about IRAs, and this is in our handout that you'll find on the website under the Secure Act. But what can you do right now with regard to your IRAs, 401ks, any asset that you have, tax-deferred annuity? You want to double-check the beneficiaries. If you don't have a copy of the beneficiary designation for each of your current active accounts, you need to get on the phone, see if you can get hold of someone at each company and confirm the primary beneficiary of each of those accounts, the secondary beneficiaries, and if at all possible, you want to get that confirmation sent to you in writing. I recognize the fact that not every business is open. McKinney & Tillman is doing its best to keep the doors open for anyone who has to come in here and sign their documents, but we're trying to do as much as possible by telephone so that you don't have to come here. We don't have to take any chances. We are sanitizing everything. So you may have trouble reaching some people, but you'll have a checklist of things that you want to do. You want to confirm that if you and your spouse are deceased and you're naming children, grandchildren, nieces, nephews, friends, that the beneficiary form specifies what happens if any one of those contingent beneficiaries should die before you. That's a question that you do need to ask. Many of our clients are very, very fond of their grandchildren. They wouldn't want accidentally to disinherit their grandchildren. So they want to know that if they name their children as beneficiaries when they're gone, that if a child should predecease them, that child's children will receive his or her portion of the IRA or the 401k, etc. So you want to be certain that the money will pass in the way that you want. You look at the beneficiaries, you look at their age, look at their financial circumstances. Another thing to look at, as we explain more in our handout on the Secure Act, is the state of residence of your beneficiaries, because all states are not created equal in terms of income taxation. So if you have a child who lives in California or New York or New Jersey, in addition to paying federal income tax on the IRA money, they're going to be paying state income tax on the IRA money. So we want you to re-examine the circumstances of each of your kids and beneficiaries, whether it's grandchildren, nieces, nephews, whatever, and make sure that the beneficiary forms conform to what you want. So what other suggestions do we have for you for estate planning in a crisis environment? First, we want you to dust off the booklet. We have a separate video on our booklet called What My Family Should Know. So again, if you go to our website, passitonwell.com, there's a free resources button that you can click on, and you will be able to find our booklet, What My Family Should Know. It's downloadable, fill-outable. You can use it as a great resource. So check out the video that we are posting on everything you need to know about What My Family Should Know. The next thing that we recommend is that if you already have one of our wonderful notebooks, that you dust off the notebook and look inside and make sure that you have everything up to date. We are doing a separate video on the notebooks. So that is going to be on our website on the free resources section. So if you look at your notebook, or if you don't have one and you're thinking about putting it together, check out our video on doing your own personal estate planning notebook, because it'll show you step by step by step what you have to do and what you have to put in there. You want to make sure that you confirm the ownership of bank accounts, of stocks, of bonds, and you want to make that confirmation in writing. So if you have a statement from the bank and it shows JTROS or JT, that usually means joint with right of survivorship. So you want to go through each of your investments and assets and see if you have documentation at home to confirm whether they're joint or in your name alone, etc. Because sometimes, long ago, you may have named a beneficiary and now you don't want that to happen. You want to be sure there's money in your estate or your trust to pay for your funeral and your debts and your expenses, and so you want to make sure there's a source of cash for that. So look at all of your bank accounts, look at all of your investment accounts and so on, certificates of deposit, etc., and confirm the ownership of each one of those assets. Then pull out the deeds to your real estate. Somewhere in that house, you have copies of the deeds to your real estate. And in Tennessee, particularly in Knox County, you can go to kgis.org and you can find a copy of the deed online and make a copy of it. And so you need to look at the deeds of the properties that you still own and make sure that you have reviewed them and that the ownership of those properties matches what you understand the ownership to be. Particularly if you have set up a revocable living trust with us, then you want to be sure that your assets are titled in a way that will match that revocable living trust. And again, we have instructions that we've given you and that we can give you for resources concerning how to make sure your revocable living trust is set up so that you will avoid probate at your death. We also want you to look at all of those assets and consider your income tax basis in those assets. For example, if you bought a rental property 20 years ago and you invested a certain amount of money, you can write that down. If you improved it, if you added a an update to the rental property. That's important for your income tax basis. If you have taken depreciation on the rental property, you want to look back at your income tax returns on the rental property schedule and see what those deductions have been cumulatively, so that if someone is going to be taking over for you, either through a power of attorney or at your death, they know these important facts. You have, many of you, business interests. You own closely held corporate stock. You own LLCs. You own partnership interests. You want to check at home and see if you have the operating agreement for the LLC. You want to see if you have the partnership agreement for your partnership interests. You want to see if you have a copy of the bylaws, and you might have to dust off the cobwebs and take a look at those bylaws, because it's typically been a long time since you checked your corporate bylaws and the governing documents. If something happens to you, your family members are going to need to know. If you're disabled, if you pass away, they're going to need to know what are the rules by which this closely held business is operated. And those documents become very important in that case. We also need to know the names and the contact information for the people that your family members are going to need to be in touch with. Your attorney, who is it that's representing you? Who is it that's helped you with your will and your powers of attorney? And how do we get in touch with them? Who is your financial advisor? How do we get in touch with them? How do we let them know that we need an update or we need information from them? Your accountant, your CPA is incredibly important. They are the professionals that you see year after year after year, or at least you talk to briefly year after year after year. So your family members need to know how to get in touch with your accountant, your financial advisor, your attorney, your doctors, and so on. Then you need to review all of your documents. In Exhibit A to this handout, and I don't know if I said this at the beginning, but we do have a handout on estate planning in a crisis environment, and you can look at that handout as I'm talking. Exhibit A to that handout is the table of contents for your notebook. If you're a single client, we have a table of contents for 19 possible items that need to be in your notebook. If you're a married individual, we have a list of documents, about 15 different documents that can be important in your notebook. So look at Exhibit A to the handout, and that will guide you in putting together your notebook. So then Exhibit B, attached to the handout on estate planning in a crisis environment, is a checklist of very important estate planning documents. Your living will, your advanced care plan. We have in Tennessee this wonderful website. You can search for it on Google, Tennessee Advance Directives, and you will find the Tennessee website on advanced care plans, living wills, etc. And you'll find some free forms there. So it's a really great resource. Your living will or your advanced care plan is a document that enables you to communicate to your family and your doctors and the people who care what you want done in the event that you can't communicate to your doctor. As long as you're mentally competent and you're wide awake, what you want done for your health care is what needs to be done for you. But if you can no longer communicate, your family members need to know what were your wishes if you were terminal and that your death was going to occur as a result of your condition. Do you want to be on life support? Do you want a stomach tube, or do you not? Tennessee gives you tools, and we have resources in the free resources section that will help you get through that if you haven't already been through that with us. So you want to provide a copy to your physicians. You want to provide a copy to the family members. The most important thing for you to do in terms of living wills and healthcare powers is to communicate with your family members what your wishes are. So that's an important thing on your checklist. You want to be sure that you store the original in a safe place. You can keep copies anywhere you want. You can give copies out to the people who are important to you. Same thing with your healthcare power of attorney. That is a document by which you authorize another person that you trust to make healthcare decisions for you if you cannot communicate to your physician and caregivers. You always name a backup or a successor on that power of attorney. So our checklist goes through the power of attorney for healthcare, the power of attorney for finances, your will. Where is the original located? Does the will cover everything? Does it need to be updated? Who has a copy? Make sure to communicate the location of your will so that people aren't trying to play detective and find your will. You need to make that easy for them to find. If in Exhibit A on the second page you have done a revocable living trust, you need to tell people where the original is located. You need to tell them if you've done any amendments. You need to go through the document itself and make sure that the current provisions match what you want right now. And if not, make a note, give us a call, we need to amend it. In a revocable living trust situation, we normally have you prepare a document, a simple one-page document, transferring all your stuff, your furniture, china, crystal, paintings, etc., into your living trust. It's called a transfer of personal property. Again, you want to look for deeds, any deeds that you have to confirm that all of the property that you have has been transferred into your living trust. If you've bought something after we helped you set up your living trust, make sure that the deed already shows the living trust as the owner. You, as the trustee of the living trust, should be listed as the owner. If that's not true, again, give us a call and let us know. We'll help you with that. One of the most important things for you to do in this crisis environment is to confirm your beneficiary designations. You have beneficiaries on life insurance policies. You have beneficiaries on annuities. You have beneficiaries on IRAs and 401ks. You have beneficiaries sometimes with bank accounts. You want to confirm that the people who are listed as your beneficiaries, first, second, third, represent exactly what you want. And so look at those and make sure you have copies. If in the past you have ever set up an irrevocable life insurance trust, you need to know where those documents are. You need to be sure that the letters that go out to the beneficiaries are all current and so on. And if you have business interests and you've created, for example, a living trust, you want to make sure that you have assigned those interests into your living trust. So Exhibit B attached to this handout on estate planning in a crisis environment is a great checklist for you to go step by step by step. What do I need to do? What's important for me to do, etc. Now, one of the things that we're going to talk about in a minute is your strong soldiers. Choosing the people that we call fiduciaries. That's our legal term for individuals that you have chosen to serve either under your power of attorney or for your estate, being the executor or the administrator of your estate, or your trustee of your trust if you can't be the trustee of your trust. All of these strong soldiers are your fiduciaries. So what we've done in Exhibit C is we have given you a very intimidating list of the duties of someone who has a power of attorney. In Exhibit C, we've got a checklist for someone who has been named to have your power of attorney, whether it's financial or health care. So that list is there as the first part of Exhibit C. Another part of Exhibit C is a checklist for a trustee. Normally, when you create a revocable living trust, you are your own trustee. But if you become disabled and you can't do it, who is the strong soldier that you've named as your successor trustee, and who's the further backup, and what do those people have to do? That's the second part of Exhibit C. It's a checklist for a trustee. Exhibit C then goes to a checklist for an executor or an administrator. If you die and you don't have a living trust, you have a will, or you die without a will, which is not a good thing to do, but if you die without a will, then the person who administers your estate is called an administrator or a personal representative. We've given you a checklist for the duties of the person who handles your affairs. If you die with a will, that's an executor, or if you die without a will, that's an administrator. Again, it's a long and rather daunting list of obligations and responsibilities that you're putting on the shoulders of those people. So you want to be really careful about who you name to have your power of attorney, to be your executor of your estate, or to handle your trust when you pass away or when you become disabled. In the handout, we have an entire section that we're not going to go over in this video about estate planning if your estate is taxable. Right now, the exemption for federal estate tax is $11,580,000. So the vast majority of humans on the planet do not now have to worry about the federal estate tax. If you do, in our handout, we've given you some tips on what to do if you have a taxable estate. And those are really valuable tips for folks who have larger estates. Give us a call if you have any questions about that portion of the handout. Next, we go to end-of-life issues. One of the things I want to talk to you about, I grew up in Oak Ridge, and we have Cold War Patriots as a program for people who were exposed to radiation in Oak Ridge, Tennessee. Check out the Cold War Patriots program and see if you or your spouse or someone in your family might qualify for benefits. Another question to ask is, do you have a cancer or other type of insurance policy to cover end-of-life issues? If so, you need to tell your family members about it. Are you of sound mind? We really need you to be able to make decisions rationally. But the standard for being of sound mind for an estate planning situation is that you know the people who are what we call the natural objects of your bounty. In other words, do you know your spouse? Do you know your children? Do you know your grandchildren? Do you know who that group of people consists of that we would expect you to include as potential beneficiaries of your estate? That's question number one. Question number two is, do you have an understanding of the length and breadth and depth of all the assets that you own or control? Do you know what you own? Because if you can tell us who your family members are and what you want them to receive at your death, then you're going to pass generally the tests of, can you update your will? Can you bring everything current and make any changes that you want to make in your will? One of the things that comes up today, more than ever because we have an aging population, is undue influence. And that's a term that we use when a person is compromised, either in health, in mind, in body, it doesn't matter, can't make really good decisions, and someone comes into their lives to help them. And all of a sudden, assets start disappearing in favor of this new caregiver or this very concerned cousin or daughter or whatever. And if they use a power of attorney and all of a sudden the property that was in the hands of the elderly person turns out to be in their hands, that's a problem that we call undue influence. Have they exerted improper or undue influence over this individual? It's a growing problem with our elderly folks, in not just in Tennessee but nationwide. So that's where these trusted soldiers are very, very important, and you have to choose really, really carefully. In our handout on the last page, we talk about having a forfeiture provision in your will. If you think your family members are going to fuss, as we say in the South, then you might consider including a clause that says, if y'all fight, whoever brings that lawsuit is disinherited. Tennessee enforces those provisions. Think about your family dynamics. Does everybody get along or not? Because if they don't, you need to face reality and not make them work together when they never have before, because they won't do it well after you're gone. Our clients are the glue that holds the family together. And so you need to consider those family dynamics when you're choosing your strong soldiers. Tennessee has a rule that's relatively recent that if anyone has ever been convicted of a misdemeanor or a felony involving a sentence of imprisonment in a penitentiary, they are disqualified from having your power of attorney, from being your trustee, from handling your estate, or being a fiduciary. If someone is taking care of you and you want them to be paid, think about a personal care agreement. You need to make sure that if you make changes at the very, very end in this crisis environment, that those changes match your will and your living trust. Don't give away something and then have a sum of money in the will that is duplicated when you don't want that to be duplicated. So you do have to make sure that if you're making last-minute sound decisions, that your documents are either revised or consistent with those choices. We do want to talk again briefly about the power of attorney because we are worried about undue influence. So to close, I'm going to share with you the song that I wrote to caution my clients about the fiduciaries and how hard it is to choose. So this is my song. Super duper trusty agent or administrator, your child will resent this job if not sooner than later. If she tries to charge a fee, the whole family will hate her. Super duper trusty agent or administrator, undo the influence, undo the lies, undo the influence, undo the lies. Choosing your fiduciaries can leave your head reeling. If you choose a rogue or rascal, there could be some stealing. Opportunities abound for lying and self-dealing. Never trust a single soul who finds this job appealing. Pass it on well.